Officer Santiago is mistaken. He's absolutely incorrect that the city hall can refuse to accept service for a lawsuit. That's not true. That's just not true. And so hopefully Captain Christian Carocchio or the head of the Danbury Police Department or whoever, however, will clear that up with all the officers on patrol that the city hall can absolutely not refuse to accept service for a lawsuit. That's not true. It's not how it works. It's wrong. Fake. False. Fake news. Hello, everybody. Welcome back to the channel. How are you doing on this fine Super Bowl Sunday? Go Birds. If you're a Chiefs fan, get out. Just kidding. So what I want to talk about today has to do with what I saw on the first day of the Danbury Long Island Audit trial. So just generally what I'm doing or what I'm trying to do is go back and watch every single moment of this trial, take notes, and kind of write down the questions that I do have as they are arising. Now, I did watch quite a bit of the trial coverage, but I haven't had the chance yet to sit down and watch it from the very first day all the way through in chronological order. There's a lot of questions that a lot of y'all have been asking about the specifics of the procedure of the trial and things like that. So that's really one of the reasons I'm going back and listening. Also, since I'm actually investigating the corruption in the town of Danbury now, or the potential corruption in the town, it's just a good exercise for me to go back and watch these videos. So I do have a video that's going to be forthcoming of kind of like my reaction to the whole entire chronological story of the trial and all of that. But it's going to take me more time than just today to do that. Today, I want to talk about something specific that I did see in watching this trial. It happens around the 30-minute mark of Sean's trial. So let me pull that up. I'll let y'all see what I'm talking about, the interaction with the Danbury police, and then we will get into a little bit of a discussion about it. Now, I am a lawyer. I have graduated from law school. I have passed the bar exam, but I gave my license to practice up. I am not licensed to practice law, and even if I was, I would not be your lawyer. So for that reason, nothing in this video should be taken as legal advice. I have to make this disclaimer as often as I can remember to, because y'all know how people try to act. Okay, so let me pull up this video. Okay, so what we're looking at here is, I guess I'll play this first part where the state's attorney, Russell Zentner, says that this is a stupid infraction trial. And to be honest, I was talking to my fiance yesterday about this. It's like when you really, really think about it, this whole entire town really did put on like a 9-day show trial for a $90 ticket. Like they really did. And I just can't help but wonder why they did that. If you're asking me what my speculation is they wasted the taxpayers' money on this trial. It's going to get appealed. It's going to come back. It's going to get overturned, in my opinion. And then they're going to be back to square one where they started. But my suspicion is that Danbury put on this show trial in this kangaroo court because they know that Sean Reyes has a valid civil rights lawsuit against the city of Danbury, against the police officers, even though they have qualified immunity. Y'all already know how that all goes. But that's kind of a side note. Now, I'll let y'all hear the guy saying it's a stupid infraction trial, and then we'll get to the Fourth Amendment piece. Stupid infraction trial. Okay, this portion of the video is where Phil Janusa is shuffling through his papers. I think it's in the next couple minutes.
Why do you need my name, sir? Why do you need my name?
I need your name, or else you can't go upstairs. I have to clock everybody in. It's the house rules.
So Phil says, I need your name or else you cannot go upstairs. And this is going to become an issue, and that's the issue we're going to be talking about today. Has to do with stop and identify statutes. It has to do with Terry, stop and frisks, etc.
But you understand that by taking my name, you know...
Either you give me your name or I can't let you go upstairs. I have to give everybody a card, and everybody's going to log in. I don't set the rules, I enforce the rules. So either you give me your name or you can turn that thing off. Then you can give me your name or else you have to leave.
I'm not going to turn my camera off, sir, respectfully.
Then you have to leave. You can't go upstairs. I have to. Everybody's logged in. Everybody
No,
have to take
all I'm saying is that it seems kind of backwards to me that to enter this is a public building, right?
It is now. It wasn't like this before the pandemic.
They're always going to take any and every opportunity that they possibly can to limit our rights and then blame it on this. You know what? I'm not even going to be able to say it on YouTube.
Now, this is what they want me to do.
But
doesn't this sound very like just following orders? Sorry I killed all those people at the camp. I was just following orders. That's what they wanted me to do. I wasn't asking any questions. Don't ask me. I'm just following orders, what they want me to do. Stupid.
Make the rules. Like I said, I just do what I'm told.
I just do what I'm told. Been knocking trees down my whole life.
You have to sign in and you have to.
He just does what he's told. Y'all think they told him to physically assault Sean in that stairwell of doom? Because I don't think they told him to do that.
If you don't want to sign in, you have to leave.
In the context of this particular case, I think it's worth noting they already knew who Sean was by this point. They definitely knew who he was because officers in the Danbury Police Department had already been suspended and disciplined. I mean, this stuff had made like literally national news at this point. There were hundreds of thousands of views on the Danbury police acting a damn fool in the Danbury library. And so it's kind of a moot point anyway for them to be getting Sean's name. They know exactly who he is. And so in my opinion, just seems like an exercise in power and control. But we're going to look beyond that and we are going to get to this Fourth Amendment issue. Pretty soon a police officer is going to show up and that's when we're really going to start talking about this Fourth Amendment situation.
You know, you're gonna turn that off or you're giving your name or you're gonna go.
Okay, listen. So all I'm trying to
What kind of decisions is that? Either you're going to turn that off or you're going to give me your name or you're going to go. What?
explain to you, all I'm trying to explain to you, sir, is that
Also, worth noting, worth pointing out, this guy, Phil Janusa, he's not a police officer. He is an allied security officer. It's like a third party, like security company that basically is like the strong arm anti-constitution league across this whole country.
I just shouldn't have to surrender my Fourth Amendment right to enter a
Don't
public
go
building.
there.
Don't go there. This is
So Sean said, I don't want to surrender my Fourth Amendment right. And Phil laughs and says, don't go there. Let me let y'all hear that one more time.
All I'm trying to explain to you, sir, is that I just shouldn't have to surrender my Fourth Amendment right to enter a public building.
There.
Sean said, I shouldn't have to surrender my Fourth Amendment right to enter a public building. So most of y'all are going to know this, but I just want to do a quick recap. The United States Constitution has incorporated into it several amendments. The first 10 amendments to the United States Constitution are called the Bill of Rights. It either gives, grants, or affirms rights to the citizens. That's what the Bill of Rights is. So the Fourth Amendment to the United States Constitution is the right of the people, that's us, to be secure in their persons, houses, papers, and effects. Secure from what? Secure against unreasonable searches and seizures. This right shall not be violated, and no warrants shall be issued unless there is probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, so this second part largely deals with warrants that are going to be given by judges. But the Fourth Amendment doesn't only apply to warrants that are issued by judges or magistrates. It applies to all unreasonable searches and seizures. The government, is not allowed under the United States Constitution, under the Bill of Rights, the Fourth Amendment, the government is not allowed to unreasonably search a person or seize any of our belongings, okay? So, as with most things in constitutional jurisprudence, the Supreme Court has had to interpret and apply different rules to cases in constitutional jurisprudence, particularly relating to the Fourth Amendment. Now, I do want you to hear what the officer, the actual police officer, is going to say to Sean. Then we're going to get into a little bit of case law, so you don't have to take my word for it, into what exactly the Supreme Court and federal courts have interpreted the Fourth Amendment to mean and to protect.
Don't go there. This is United States of America.
I am the guard here. I don't make the rules. I enforce the rules. This is what they want me to do. They want me to take your name, give you a card, and you go upstairs. Maybe in a month.
Now, easily, Phil Janusa could have just written down Sean's name, right? He knows Sean's name. He knows who Sean is. And he's just trying to strong arm Sean. And Sean said, I don't want to be unreasonably searched or seized. And it's going to become a question whether it is unreasonable search and seizure for them to demand, to force Sean to turn over his ID or to give up his identification to use a public facility.
I'm a rotten person, yeah.
Your name is Janusa.
Look, buddy, either get out
Now he's putting his hands on Sean.
So you give
Don't
me your
touch me,
name.
man. Don't touch me.
Hang on a second.
Don't touch me, man.
Hang on a second.
Yeah, do
He won't
that.
give me his name.
Do that. So are you
I'm trying to-
supervisor?
You have to give me your name and you have to take a card.
Oh, I just don't want to surrender my Fourth Amendment right to enter a public building. That's all.
So-
I'm here to see the town clerk. I have business here. You can't refuse me from having business here. Exactly.
You have to, for the last
No, I
time,
do
turn
not.
the thing
No,
off.
I do, and I'm not
You're
turning
getting
it
under my
off.
skin.
For what purpose? This is a
Why
first.
can't
This
you
is
give
a
me
First
your name?
Amendment.
Give me your name and you go upstairs. It's simple. I'm not asking.
He knows his name. That's the most hilarious part of this whole thing to me.
Just call Jan.
I'm just here to serve her. That's all.
That's Lion Jan,
Dead with his teeth missing. There goes Lion Jan.
who allegedly perjured herself on the stand in the stupid infraction trial.
Whether she wants to come down or not.
Janice R. Giegler, I'm here to see.
Right.
There's no need to call the police.
Okay, I fast forwarded a little bit. Y'all can go and watch this trial yourself, or you could also go and watch, the original video that is up on Sean's Danbury playlist. I'm trying to get to the part where these cops are, so just bear with me. Okay, so we're at the 37-minute, 20-second mark, and the Danbury police officers have now shown up, and they're in the lobby of the city hall.
Gentleman wants to go up to see Jan, up to the town. He's got a log in his name, he's going to take a card. He doesn't want to relinquish his name, and he wants to go upstairs. And he keeps filming.
Yeah, so I'm filming everything because I'm a journalist. I'm gathering content for a story, so that's my First Amendment right. This is a public building. I'm not going to relinquish my name because I shouldn't have to relinquish my name. That's a violation of my Fourth Amendment rights to relinquish my name. This is a public building. I'm here to conduct official business. You guys already violated my rights yesterday.
So the guy with the face mask is Adam Cantor. He is an officer with Danbury Police Department. David Santiago is the other officer. I think it's Santiago who is going to be the one making claims about the Fourth Amendment here.
Serve a notice of intent to sue. That's all I'm trying to do, and I would have been out of here, in and out. That's it. I'm not breaking any laws. This is a public building. It doesn't matter. They can't refuse service to me.
Yes, they can, sir. Yes.
Okay, first of all, I'm not going to bury the lead. They really cannot refuse service to him because the service that Sean is describing is being able to serve the lawsuit on the city. So they really can't refuse to accept the lawsuit. That's just not something that they can do. That is Jan's job. She took an oath to do that job specifically. It's the person who would accept a lawsuit for the city is Jan. So out the gate, Officer Santiago is mistaken. He's absolutely incorrect that the city hall can refuse to accept service for a lawsuit. That's not true. That's just not true. And so hopefully Captain Christian Carocchio or the head of the Danbury Police Department or whoever, however, will clear that up with all the officers on patrol that the city hall can absolutely not refuse to accept service for a lawsuit. That's not true. It's not how it works. It's wrong. Fake. False. Fake news.
It is a public building, but if they want to refuse service,
I just want to get your guys' name. Cantor 683, Santiago 685. Yeah, so guys, this is unfortunately you're wrong. This is a public building.
so what would you like us to do at this point?
I would like to conduct my business. I have business here. This is a public building. I don't have to give my name. There is no law
Who are you
saying
looking to speak to?
I have to serve this paperwork, this legal document, onto the town clerk.
Okay, if the town clerk came down here, would you like to speak?
If she wants to come down here, that's fine.
That's an option?
Yeah, sure.
Would that be an option or no?
Sure.
It really is quite ridiculous, just as a side note, that there's 3 armed law enforcement officers to show up because there's one guy at the city hall with a camera and the guy, they already know who it is. It seems retaliatory. It seems like, frankly, harassment. But that's just my opinion. What do I know? So now they're going upstairs to get Jan and pull her out of her cave so she can come downstairs and accept service for this lawsuit.
Can I get your name, sir?
I'm sorry?
Can I get your name, sir?
Officer Benson, badge number 674.
Thank you so much.
What's your name?
I'm not going to give it. You guys know. You guys
I
know.
know. First time in my life.
Never seen you.
Well, you guys, no, I'm saying you guys, I'm not from here, but, you guys got my name and stuff yesterday.
We're not all the same.
I just left the PD.
So, unfortunately, listen, I don't have a say on what their rules and regulations are. That's up to the city. The city clearly has this in place, Visitors, if you'd like to sign in, you're more than welcome to. You can sign in. You can go do whatever you got to do.
Yeah.
My question is, what if the city wanted to all of a sudden implement something that said no Christians allowed in this building? You got to give up serving Jesus the Lord if you want to get in this building. Are the police going to enforce that? Or what if it's like, when you walk into this building, you have to submit to a strip search, right? Like, oh, well, that's the rules here. We just got to follow them. Like, it's such a slippery slope. And that's why we have a legislative process. The legislators make laws which are supposed to be voted upon by elected representatives. It's not supposed to be any old city hall can make any old rule that violates the Constitution. And then the police show up with guns and bulletproof vests in order to enforce these unconstitutional silly little rules and policies. That's why we have a legislative process. But no, Santiago does not understand that. In the very least, he does not understand it. He's like, well, I'm just following orders. I don't know. It's just they got rules, and you just gotta sign your. No, shut up. What? That's not how it works, and you should know that.
But as far as
So you literally just said a name, right? So you literally just said a name, right? So what's the issue?
I've rewinded this part a couple times and Sean's saying you literally just said a name. So I'm assuming the guy did say Sean's name. I was going to try and rewind it and show y'all. I don't see it. I can't find it. I don't want to spend more time doing this because things to do. But apparently the guy says Sean's name and he's like, you just said my name or a name. So clearly you know it. So what's this stop really about? Why are you really trying to get my name if you already have my name? It's almost like they knew that Sean was suing the city because that was the whole point. That's why he's there. He has a lawsuit in his hand to serve on the city. And maybe now they're trying to figure out what kind of ways they can combat this lawsuit. Maybe. I don't know. It's my opinion that this whole thing is a big conspiracy against Sean and against the Constitution. But what do I know? Just my opinion.
there's no issue, I'm just trying to help you resolve it.
Okay, great. So you got what you believe is my name, and I'm trying to go upstairs to serve a legal document. That's it. And then I'm out of here. This is a public building. If I wanted to walk around here all day and record a notice of intent to sue, this is a legal document that I'm serving. No, you have to serve it on the town clerk. That's the way it works. I need to serve it to a Janice R. Geigler. I have a right to film here. You know what I mean? I do this all the time. You guys have no legal authority to stop me from filming. You have no legal authority to eject me from a public building. This is public. I'm not breaking any laws. That sign-in sheet is not law. So you guys aren't policy enforcement. You guys are law enforcement. So all I'm asking is to let me conduct my business in this public building that I have a right to be in and go about my day.
If they don't want you here, you're gonna have to leave.
That's not true. If they don't want you here, you're going to have to leave is not true. That's another fake news coming from Santiago.
So I'm gonna be trespassed from town hall?
You will be, yes.
Are you telling me I'm trespassed as of now?
Trespass right this second.
Okay. Well, you let me know.
The way it
Okay.
keeps on going, you can be trespassed. Yes, you can.
Okay. Well, I guess I'm gonna have to do another one of these, man. Because you guys are. Can I request the supervisor, please? Thank you. Appreciate you guys. You guys got a lot to learn over here, man. Seriously. I'm not trying to be an asshole to you guys. I'm not trying to be. I'm really not. All I'm really trying to do is stick up for my rights.
What's the whole issue? You just don't want to sign in?
Yeah.
Okay, so now we're at the meat and potatoes of this video. So one of these officers, I don't know which one, they said, what's your whole issue? You just don't want to sign in? And Sean said, yeah, that's the whole issue.
Because, no, I'll catch you up. So it's the Fourth Amendment prevents searches and seizure. So I shouldn't have.
Just to be very clear, the Fourth Amendment prevents unreasonable searches and seizures, which I'm sure Sean knows and I'm sure he meant. It's just like when you're live and in the middle of all of this, he probably just forgot to say it. But the Fourth Amendment doesn't prevent searches and seizures generally. It prevents unreasonable searches and seizures. And we are going to get into what that means in just a second. Like I said, I want y'all to watch this full little interaction play out and then we're going to talk about it.
To relinquish that right to enter a public building. That's all I'm saying. The Fourth Amendment prevents searches and seizure. So I shouldn't have to relinquish that right to enter a public building. That's all I'm saying.
So at what point did someone search you or seize you?
No, that giving my name.
So the officer says, kind of like, I don't know if he's trying to be glib, if he's just stupid. I really don't know. But he says, so at what point did someone search and seize you? We are going to talk about it, but I'm just giving y'all the translation here in case the audio is hard to hear.
Name, yeah,
Giving your name is not being searched.
yeah. It's you're seizing my name.
That makes
You're forcing
sense,
me.
sir.
Yes, it does. Okay, it does.
Search and
It does.
seizure. The Fourth Amendment applies to motor vehicle, housing, and your person as far as physically.
My personal identity.
So the disagreement here between Sean and the officer is starting to form. And the disagreement seems to be that the officer believes that you have to be physically restrained and the officers have to physically take something from your actual person or your physical belongings from your car or your house, which that is true. That is true. That's part of the Fourth Amendment. But it does seem like the officer doesn't fully understand how far reaching the Fourth Amendment does go. So then you have Sean, on the other hand, who is saying, yeah, maybe all that stuff is true, but to take my name alone, just to take my first and last name from me, is an unreasonable search and seizure. That is the argument that these two men are having.
Identificate my personal information.
Not like that, no. So
It does, but
it does not.
So the officer says it does not work like that. Sean says it does. The officer says no, it doesn't. So we have like a literal schoolyard going on.
okay.
With people who put their hand on a Bible or some other book and said, I promise to uphold the United States Constitution. They put their hands up in the air.
Alrighty. I don't wanna argue.
Somebody be violating your Fourth Amendment right would be like me illegally searching your car.
True. I mean, the guy's not wrong. Illegally searching the car would also be a Fourth Amendment violation, but it goes a little farther than that.
Or me just busting in your house and illegally searching your house.
Mm-hmm.
That's what the Fourth Amendment
Sean's so funny.
applies to.
Okay.
Again, this is their policy. That's what they want. That's up to them. When the supervisor comes, we'll make a decision as to what's going to go on.
What I will say is, I went to Danbury just last week into the city hall, and there is no more desk at all where Phil Janusa is, and there's no longer a sign-in requirement. So I guess for whatever reason, they went ahead and did away with that policy.
Okay. That's great. That's great. Santiago, just let me know whenever you want me to, whenever you're telling me to leave under threat of arrest. Okay.
Okay, no problem.
All right. Thank you. Because the minute you say those words, I'm going. All right.
Listen, we're not trying to harass or anything like that.
No.
They're not trying to. We're not trying to harass you or anything like that.
If you wanted to do something, you have to just obey the rules.
Yeah.
If you want to do something, you have to just obey the rules. No,
That's the only thing.
the rules have to make sense and be constitutional, buddy.
Like I said, it's their policy.
Yeah.
Right? You know, it's
But
not
just,
ours.
Again, y'all, what if the policy was, in order to enter into this building, you got to pay us 10 grand. In order to enter into this building, you have to be white. In order to enter into this building, you have to be a man. That could be a policy. Are the police officers going to show up and enforce that? Honestly, probably based on how they just follow orders in this damn town.
understand what you're saying, but let me just say it like this. Maybe this will paint a better picture. So the way it works is that the Constitution of the United States is on top. Then it goes laws, statutes, and then policies and stuff like that. So if the
So what Sean is describing is the doctrine of constitutional supremacy, such that the Constitution is the supreme law of the land, even on a state by state basis. States, cities, townships, etc., may not, shall not, are not allowed to enact laws which violate the United States Constitution. They can make laws about stuff that the Constitution doesn't mention. But if the Constitution particularly protects a right, cities and towns and townships and things are not allowed to make laws which would violate the Constitution. So what Sean is describing here is the doctrine of constitutional supremacy, and he's doing so to kind of educate these officers. He's saying, look, even if it is a policy that I have to give over my ID or give my identification, for example, which is different than your government issued ID, just identifying yourself is what Sean is talking about, is that even if there's a policy here, it cannot violate, it cannot trump the Constitution. And right now, because there's a conflict between the Constitution and the city ordinance, y'all have to follow the Constitution. Even if this is a rule for the silly little city hall, you cannot enforce it. That's what he's trying to explain.
Constitution says I have a right to be here, that can't stop me from coming in here. So that's my point. And like I said, you might disagree, but I've done this enough times to know that what I'm saying is very, very true. And, obviously,
Are you from Denver? Or?
no, I'm not from Danbury, but
They always love asking if people are from Danbury or from wherever. They always like asking auditors in all these auditing videos, like, where are you from? You're not from here, are you? Like, so what if he is?
yeah. No, but I travel all over and do the same exact thing everywhere.
Okay, so that's pretty much just the interaction that I did want to show y'all. Now, let's get in a little bit to the constitutional jurisprudence. And what we will start with is probably going to be Terry versus Ohio. So, what we're dealing with here is along the veins of a stop and identify statute. Now, stop and identify statutes where they are laws, which doesn't seem to be the case here in Danbury because I could not find any stop and identify statutes in the whole state of Connecticut. I could not find. That doesn't mean it doesn't exist. I just couldn't find it. But stop and identify statutes are subject to jurisprudence and the progeny of Terry stops and all relating to the Fourth Amendment having to do with unreasonable searches and seizures. So there are laws in the United States and different states. I think it's about 20 to 25 states have these stop and identify statutes. And what they do is authorize police officers to lawfully order people to give over their ID or to provide the police officer with their identification information if they don't have a physical ID. So, in every single jurisdiction where one of these stop and identify statutes is on the books, the police officers are only allowed to demand identification in the case where the police reasonably suspect a crime. It's not just any old crime. It has to be a crime that's already happened, a crime that's in the process of happening right now, or I call it the fixin' to or the fidna standard. I made that up myself. A crime is fidna occur, not like gonna occur sometime in the distant future, but like right now it's about to happen, right? And that's why I call it the fidna to. Now, I did have someone on here the other day that was like, stop saying y'all. It makes you sound uneducated. Let me tell you one thing. I come from a long line of Southerners. I'm like a 12th or 13th generation Louisianian. And if you think you're going to get y'all out of my vocabulary or even my DNA because I lived in the Northeast for 7 years, you are incorrect. If you can't get past somebody saying the word y'all, that's a you problem. You need to go talk to the Lord about that because I'm about to say y'all. Thank you. So back to these stop and identify statutes. Now, if you remember, the point of contention between Sean and Officer Santiago is that Sean says, you taking my name without me committing a crime, you taking my name and demanding that I give you my identification in order for me to access this public building is a violation of my Fourth Amendment rights against unreasonable searches and seizures. Santiago says, no. I have to be physically trying to take something from you, physically going into your house, physically going into your car to violate your Fourth Amendment right to be free from unreasonable searches and seizures. So now we're going to get into who's right. And spoiler alert, it's not the officer. So in all of the jurisdictions, Connecticut's not one of them, that has stop and identify statutes on the books, every single one of them requires there be a reasonable suspicion that a crime has been committed, it's being committed actively, or it's going to be committed. So the Fourth Amendment of the United States Constitution prohibits unreasonable searches and seizures, and it requires warrants to be supported by probable cause. That's what we just discussed when we read the text of the Fourth Amendment. Now in 1968, the Supreme Court of the United States had occasion to re-examine the Fourth Amendment and determine when exactly the state or a government official, a law enforcement officer, etc., can demand identification from a suspect. Now, in that case, another huge one, big like Brady, big like Miranda, right? It's a big case that everybody studies in law school. Everybody knows about it. It's called Terry versus Ohio. Again, 1968. Now, in Terry versus Ohio, the United States Supreme Court confirmed that it is constitutional for police to temporarily detain a person, which means they can hold the person and not allow the person to leave temporarily, but it had to be based on, and I'm quoting here, specific and articulable facts that establish reasonable suspicion that a crime has been or is about to be committed. Okay. Now, the Terry case also dealt with pat downs, which we're not dealing with in Sean's case here. And that was based on reasonable suspicion that the person might be armed. We could get into all that, but we won't because that's not part of what we're talking about today. Now, there was another case in 2004 called Hybel versus the 6th Judicial District Court of Nevada. That was 2004. And it went all the way up to the Supreme Court as well. The Supreme Court held that statutes requiring suspects to disclose their names during a valid Terry stop did not violate the Fourth Amendment. But the Terry stop had to be valid. And if you remember what we just discussed just a moment ago, in order for a Terry stop to be valid, the officer must have specific and articulable suspicion, and it must be reasonable that a crime is being committed. So applying that constitutional jurisprudence to Sean's case and his argument with this officer, these officers, in order to demand Sean turn over his ID, meaning disclosing his name, because the Hybel case did deal with just disclosing your name. It's not turning over your ID. It's just telling your name. It's not unconstitutional to do that. It's not unconstitutional to demand Sean to turn over his name. If there's a big if there's reasonable, specific, and articulable suspicion that Sean is engaged in or has just now been engaged in criminal activity, okay? So the officers need to be able to articulate a reasonable suspicion that Sean is committing a crime. And from this video that I'm looking at, I don't see which crime he is allegedly committing. Now, there's all this other question about trespassing, and they are discussing trespass. But in order to be trespassing, it's another one of those criminal requirement type of situations where you can't be trespassed simply from being in the building. You have to be committing another crime. Now, interestingly, in Sean's case, from a procedural perspective, he was not found guilty of disturbance or disturbing the peace or whatever the name of the statute is in Connecticut. And that would have been the underlying crime that would have made the trespass charge be able to stick. So from a procedural perspective, it's unclear to me how Judge Stanko ever arrived at the conclusion that Sean was trespassing. But here in this case, according to Terry and Hybel, officers are not presenting Sean or anyone else with specific and articulable facts that would establish reasonable suspicion that Sean has committed a crime. In fact, Sean is saying over and over, I'm just here to serve this lawsuit and then I'm going to be on my way. In the last decade or so, there's also been a few cases that have been decided which address this issue specifically. Not quite as big of a deal as Terry in and of itself, but it is part of the progeny of Terry, and it's part of the legacy of the Terry decision. So one such decision is from New York City. I just want to read this one to y'all to discuss other times, other ways, other places where things like this have happened. Sorry for the small text. This is as big as I can get it. So this article is from November 2015. I'm not going to read the whole thing, but this is from the case Floyd versus the City of New York. This one was decided by the Southern District Court in New York. So this one had to do with the profiling of race. Now, what ended up happening in this case was they were doing a lot of these stop and frisks under the guise of a Terry stop. But unfortunately, the officers in these cases did not have specific articulable facts to support that they had probable cause that crimes were being committed. In fact, they were just kind of targeting people based on, skin color and what clothes they were wearing and stuff like that. So this was a ruling in 2015. The District Court for the Southern District of New York held that the City of New York was liable for violating the 4th and 14th Amendment rights of Black and Hispanic plaintiffs in a class action and ordered permanent injunctive relief in a non-jury trial. New York City was held liable of 4th Amendment violations, including the widespread practices of unconstitutional stop and frisks by the New York Police Department. Now, the District Court, the federal court, in rendering its opinion, ordered immediate and eventual reforms to the policies, practices, training, supervision, and documentation of these violations. They allege that the New York Police Department and the city violated their 4th Amendment rights through unjustified stops, and they allege that their 14th Amendment rights were violated by targeting them based on their race. And so here's the 4th Amendment discussion. The 4th Amendment allows a police officer to stop a person if the officer has a reasonable suspicion supported by articulable facts, and it has to be based on an objective standard that possible, quote, criminal activity is occurring or is imminent. These stops are known as Terry stops, and they're called that based on the Terry case from 1968. So the rest of this kind of talks a little bit about the 14th Amendment, equal protection violations, stuff like that. I want to talk about one other case. This is the ABA Journal from a 2021 article. So what it says is police officers who arrested a black man after he refused to identify himself violated his Fourth Amendment rights. But those police officers have qualified immunity because they relied on a county ordinance that made it a crime to refuse to provide ID to officers. The February 4th decision by the U.S. Circuit Court of Appeals in Richmond, Virginia, upheld dismissal of George Wingate's claims against the officers based on enforcement of the ID ordinance, but it did find for him on another claim that one of the officers wrongly told him he was not free to leave until he provided the ID, which turned the police encounter into an investigatory stop that violated the Fourth Amendment. Okay, so do y'all see what happened here? When the officer told the plaintiff in this case that he was not free to leave until he provided ID, it took it from a Terry stop, which is just a stop and identify type of situation, to an investigatory stop. It leveled it up, which pulls in a lot more of your constitutional rights when you're not free to leave. And in so doing, just requiring him to provide identification before he could leave or before he could carry on was a violation of the Fourth Amendment. The court in this case, the appeals court, revived the wrongful stop claim and returned the case to the district court for further proceedings. The chief judge, Roger Gregory, wrote the unanimous panel opinion. I think it must be 3 judges, and it was unanimous. The incident happened in April 2017 in Virginia after Wingate pulled his car over at around 2 a.m. because his check engine light was on. A former mechanic, he thought he might be able to fix the problem, pulls out a bag of tools from his trunk, looked under the hood, then he got back into his car, tried to diagnose the problem using a code reader. An officer pulls over and offers assistance. Wingate left his car and walked to greet the officer. When the officer asked what was going on, Wingate said he was on his way to his girlfriend's house, but had pulled over after experiencing car trouble. The deputy asked Wingate at that point to disclose his identity. And then Wingate rightfully asks, have I committed a crime? He's looking for that reasonable, articulable suspicion of criminal activity. The officer said he had not committed any crime. So no articulable suspicion because he didn't articulate any suspicion. He says, am I free to go? The officer says, no, he is not at the moment free to go. Wingate says, am I being detained? The officer said he was not. Then Wingate says, okay, so then am I free to go? Officer said he was not, and he would not be free to go until Wingate provided ID. A second officer, of course, shows up to the scene and said that there had been a lot of catalytic converter thefts in the area. And Wingate was on the side of the road in an area where businesses had been hit. After Wingate again refused to provide his identification, the officers attempted to arrest him. Wingate resisted, broke free, and ran. Officers caught up to him, handcuffed him, and placed him in the patrol car. So that's an arrest. When they searched Wingate's car, they did not find tools commonly used to steal catalytic converters. Prosecutors later did drop the charges against Wingate. Just like in Sean's case, later they did drop the charges other than the stupid infractions. Wingate sued the officers under Section 1983 of the Civil Rights Act and Virginia common law. The officer in the case argued that the investigatory stop was constitutional because he reasonably suspected that Wingate was involved in criminal activity. The notion that the driver of a broken down vehicle creates suspicion of criminal activity by approaching the officer trying to render him aid defies reason, is what the court said. The officers violated Wingate's Fourth Amendment rights by enforcing the ID ordinance outside of the context of a valid Terry stop. That's what the appeals court said. And they, again, relied on Terry. Prior court cases should have placed the first deputy on notice that suspicion of criminal activity must arise from conduct that is more suggestive of criminal involvement than wearing dark clothes and pulling over because your car broke down or whatever. As a result, the deputy was not entitled to qualified immunity on that particular charge. So that's all I really had for today. As far as the disagreement between Sean and Officer Santiago goes, based on the constitutional jurisprudence and my understanding of it, this is not legal advice, Sean was correct and Santiago was wrong. Unless the Danbury police could articulate and had reasonable suspicion that Sean had just committed a crime, was in the process of committing a crime, or was about to right now commit a crime, there's no requirement that he has to turn over his ID in order to access a publicly funded, publicly available, public building. So again, this is not legal advice. Now, I will be making another video soon about the follow-up of the Foia request that I did make to Danbury. I Foia requested the body camera footage from Jacobellis that was allegedly apparently redacted whenever it made its way over to Sean in the evidentiary bundle. And so the small update that I can provide you with right now is I did receive the body camera footage and it is missing the audio from that part. I did correspond with Christian Caraccio on Friday. Today is Sunday. And when I corresponded with him, he was like, oh, there should be 2 files in the zip folder that I sent via the Axon system. That was not the case. There's 1 file in the zip folder. There's only one, and the one that I have is missing audio. Now, it raises other questions, such as why are there 2 separate files, one that has audio on that part and one that does not? I don't know. But yeah, I will certainly keep y'all updated. Captain Christian Caraccio said that he was not going to be in the office again until Tuesday. And on Tuesday, allegedly, according to him, he's going to send me what I actually asked for. If he does not do that, I certainly will be updating y'all and letting you know the whole entire way through what I get. All right. That's all I really had for today. And yeah, enjoy the Super Bowl. Fly Eagles fly. Go Birds. And I'll see y'all on the next one. In the meantime, facts ain't defamation. Love you, mean it. Okay, bye.